and a very warm welcome to thorough newspaper analysis for 4th of April, which is brought to you by LawSikho. Now let's proceed with the agenda for today. At the very outset, we're going to have a look at some of the important national and international news updates. This is going to be followed by a legal news update. And at the very end, we have an editorial to discuss by the title of Sales Tax and Actors Copyright. See, essentially in this particular editorial, the author talks about the plea which was before the Honorable High Court of Bombay, brought about by actor Anushka Sharma, wherein she challenged or impugned the order or the notices which were issued to her by the concerned tax department, asking her to pay sales tax of certain amount for the year 2012 to 2014 on her income that she generated out of ad revenues and also her performances in award functions. So with this, let's start with the TNA for today. The first update is with respect to India Post Payments Bank launching its banking services on WhatsApp. So the state-owned India Post Payments Bank, it has partnered with Bharati Airtel to launch banking services through WhatsApp for its customers. This newly launched WhatsApp Banking Connect channel, it is going to enable the bank's customers to connect with bank on WhatsApp and also effortlessly avail a host of other banking services, including doorstep service requests and locating the nearest post office. Moving on to the next update, which is with respect to Adani Ports acquiring the Karaikal port. So recently, Adani Ports and Special Economic Zone Limited, it has announced the successful acquisition of the Karaikal Port Private Limited after receiving approval from the National Company Law Tribunal. Karaikal Port essentially is a sizable all-weather deep water port which is located in Puducherry, India, with 5 functional berths, 3 railway sidings, over 600 hectares of land and an existing cargo handling capacity of 21.5 million metric tons. Moving on to the next update, which is with respect to a new development in the geopolitical segment. India and Malaysia has recently agreed upon using local currency for their trade. So the Ministry of External Affairs has declared that trade between India and Malaysia, this can now be conducted using the Indian Rupee, which is INR, as a mode of settlement in addition with other currencies. See, this development, it has followed the launch of the foreign policy of 2023, with respect to which we're going to have a discussion later also. By the Ministry of Commerce, this policy was launched. Now, this move is expected to boost bilateral trade between the two countries and reduce transaction costs for businesses. It is very important for us to understand that this decision in trade in local currencies, this is a part of broader trend towards currency swap agreements between various countries. These agreements are essentially aimed at reducing reliance on the US dollar as the dominant currency in international trade and finance. Now let's talk about what is the implication that this particular move is expected to have on India and Malaysia ties. So see, for India and Malaysia, this move is going to be significant because these two countries have a long history of trade and investment ties, and bilateral trade between the two countries has been growing steadily in recent years. However, much of this trade has been conducted in US dollars, which has created additional transaction costs and currency risk for businesses. Therefore, with the introduction of local currency, this particular concern of US dollar being the dominant currency, it is going to be addressed. Now, the next update is with respect to the launch of an app called Sagar-Setu. So the Union Minister for Ports, Shipping, Waterways, Shri Sarbananda Sonowal, he launched the app version of the National Logistics Portal Marine called Sagar-Setu. This particular app is going to provide real-time information of activities that are generally not in the reach of importer, exporter and customs brokers, including vessel-related information, gate container freight stations, transactions on fingertips. It is also going to enable digital transactions for payments required for the clearance process of import and export, like container freight station charges, shipping line charges, transportation charges, etc. Moving on to the next update in the national segment itself, which is with respect to the government unveiling the foreign trade policy for this year. So the government has released the foreign trade policy for 2023 on Friday. This policy is aimed at increasing India's exports to US $2 trillion by the year 2030. The policy proposes to shift from an incentives-based regime to a remission and entitlement-based regime in order to achieve its goal. Next, we have an update regarding the India Post releasing a commemorative special postal cover to celebrate the Golden Jubilee of IIM-Bangalore. Now, the next update is in the segment of personalities. NASA recently has appointed Indian-origin Amit Kshatriya to head Moon to Mars program. Amit Kshatriya he is an Indian American engineer with expertise in software and robotics. He has been appointed as the inaugural head of NASA's newly established Moon to Mars program. As part of his office nature of work, he is going to be responsible for planning and executing human missions to these celestial bodies for the betterment of humanity. The newly established Moon to Mars program office, it has been created to assist NASA in achieving its ambitious goal of landing humans on Mars and conducting exploration missions on Moon. Now, this is an interesting update wherein an Indian origin scientist has developed world's first energy saving paint, a brand new heat repellent paint that is available in any color and it is expected to last for centuries. It has been developed by an Indian origin scientist. This is world's lightest paint. Professor Debashish Chanda of the University of Central Florida's Nanoscience Technology Center has used inspiration from butterflies to develop the first environmentally sound, mass-produced and multicolored substitute for pigment-based colorants which can aid in energy saving initiatives and also to counteract the global warming concerns. This discovery, the news regarding this, it was published recently in an article in Science Advances. Now, the next update, it is with respect to Miami Open. Russian tennis star, who is Daniil Medvedev, he has claimed his fourth title of the year by defeating Jannik Sinner in the closely contested final match in Miami Opens of 2023. Medvedev, who was once the top-ranked player in the world, has now won 24 out of his 25 matches, including his latest victory at the prestigious Miami Open. The win marked his first ever title win at Miami Open. As far as this tournament, Miami Open, it is concerned, it's a professional tennis tournament that takes place annually in Miami Gardens, Florida, US. It was first held in 1985. Now with this, we've come to the international segment for today. European Commission has granted GI tag for Himachal's Kangra tea. European Commission has granted protected geographical indication PGI for India's unique Kangra tea, which is grown in Himachal Pradesh Kangra district. The EC, European Commission, it notified grant of the PGI PGI tag on March 22, and this will come into force with effect from April 11 of this year. Now, the next update in the international segment itself is with respect to the International Monetary Fund approving $15.6 million support package for Ukraine. The fund has been approved to support Ukraine to assist the country with the conflict hit situation that it is facing currently. The loan is part of broader $1.15 billion international support package to help the country meet urgent funding needs. Now, the third update in the international segment is with respect to Finland becoming 31st NATO member. So the Finnish flag is due to be raised at the NATO headquarters in Brussels as Russia's western neighbor becomes 31st member of the Western Alliance. Finland's accession is a setback for Russians Vladimir Putin, who repeatedly complained of NATO's expansion before his full-scale invasion of the Ukraine. And with this, we've come to the legal segment update for today. The first update the only update that we have for today, it is coming from the High Court of Delhi. The Honorable High Court of Delhi has recently held that the order of the Arbitral Tribunal rejecting the application for impleadment of parties in the arbitral proceedings, it does not constitute an interim award under the Arbitration and Conciliation Act of 1996, since it does not decide any substantive question of law or deal with the merits of the case. The name of this particular case is Goel MG Gases Private Limited versus Panama Infrastructure Developers Limited, Private Limited, and others. And lastly, we have the segment of editorial for today. So the title of this particular editorial is Sales Tax and Actors Copyright. See, firstly, let's understand the why of this particular article and what is the issue in this particular article. तो देखिए essentially हुआ क्या था, अनुष्का शर्मा she approached the High Court of Bombay because she was issued orders by the Mazgaon Sales Tax Deputy Commissioners, and in particular orders में the tax department उन्होंने ये कहा था कि 2012 and 2013 and 2013 and 14 in दो bracket of years में अनुष्का शर्मा was liable to pay sales tax under the Maharashtra Value Added Tax MVAT Act of 2002, and जो उनसे टैक्स की डिमांड करी गई थी वो अमाउंट था, the amount that was demanded was rupees 1.2 crore and rupees 1.6 crore including interest on rupees 12.3 crore and rupees 17 crore respectively, that Anushka Sharma received as remuneration for ads and performance at award shows in the year 2012 to 13 and 13 to 14 respectively. Now, since this order was passed or issued to Anushka Sharma, she approached the High Court of Bombay. Now, before the Honorable High Court of Bombay, the crux question that came up for consideration was whether the actor has copyrights on her performances and whether they have to pay sales tax for the same. तो सी बॉम्बे हाई कोर्ट ने रिफ्यूज़ कर दिया टू इंटरवीन इन दिस पर्टिकुलर मैटर, एंड रीज़न उसका ये था, हम आगे भी डिस्कस करेंगे, कि जो पर्टिकुलर स्टैट्यूट है उसमें एक और अथॉरिटी है जहाँ पे आप अपील कर सकते हो इस पर्टिकुलर ऑर्डर के रिस्पेक्ट में. सो बाय वर्च्यू ऑफ द फैक्ट देयर इज़ एन इक्वली एफिकेशियस रेमेडी अवेलेबल to the actor, therefore the Bombay High Court did not intervene in this particular matter. So with this, let's start with the editorial. We're going to have a discussion around what was the matter before the Honorable High Court. Then we're going to have a look at the arguments which were advanced by both set of parties, actor Anushka Sharma and the tax department. And then this is going to be followed by an understanding of section 38 and 38 A of the Copyright Act on performers' rights, कि वो performers' rights क्या होते हैं, and at the very end we're going to have a discussion around what the High Court held. So let's start with the editorial for today. See, essentially, Anushka Sharma moved the High Court against the order which was issued by the Mazgaon Sales Tax Deputy Commissioner raising dues for 2012 to 13 and 13 to 14 under the Maharashtra Value Added Tax of Act of 2002. The demands were, as we already discussed, it was for rupees 1.2 crore and rupees 1.6 crore including interest on rupees 12.3 crore and rupees 17 crore that Sharma received as remuneration for ads and for performances at award shows in these 2 years respectively, 2012-13 to 2013-14. Now let's understand what were the arguments of the tax department. So essentially they argued that Anushka Sharma, she was the first owner of copyright. उनका ये कहना था कि दी एक्टर, क्योंकि वो फर्स्ट ओनर है अपने कॉपीराइट का, एंड फर्दर उन्होंने उसको ट्रांसफ़र कर दिया बाय अ 3 पार्टी अग्रीमेंट, जहाँ पे यशराज फिल्म स्टूडियोज़ जो थे वो उनके एक कॉन्ट्रैक्टर थे. तो क्योंकि उन्होंने ट्रांसफ़र कर दिया शर्मा ने अपना कॉपीराइट, तो शी हैज़ रेंडर अ सर्विस एंड देयरफॉर शी इज़ लायबल टू पे टैक्स हियर. नाउ लेट्स अंडरस्टैंड दीज आर्ग्यूमेंट्स इन डिटेल. Sharma received remuneration as per the taxman's argument. She received remuneration under the terms of tripartite agreement in which Yashraj Films was her agent and the third party. So according to the tax department, Sharma, who is the first owner of the copyright on all her artistic work, she sold that right through these agreements and was hence liable to pay sales tax, and was not just treated not just treated as her personal income. It cannot be treated as her personal income. Rather, this was a transfer of her copyright, and therefore she was liable to pay sales tax. Section 6, subsection 1 of the MVAT Act of 2002, it was cited, which provides that there shall be levied a sales tax on the turnover of sales of goods. Sales tax is an indirect tax which is levied on the sale of goods by individuals and or entities engaged in selling activities. This has been now replaced by the GST. Income tax is a direct tax which is paid on income. Now the taxman argued before the High Court that the actor was providing services and earning income through a contract for service and not through a contract of services. she was not employed. अब now let's understand कि contract for service and contract of service में difference क्या होता है. देखिए contract for service it is when one wants to engage the services of a third party as an independent contractor for a specific purpose. जबकि contract of service क्या होता है, जैसे कि हमारा employment contract होता है वो similar is contract of service. Now Anushka Sharma is an actor by profession and a copyright in her is created in her artistic performance, which is recorded by various company clients and used for commercial purposes, the taxman argued, further adding that in Anushka Sharma's case, along with the artistic performance, the copyright gets transferred and used by her client company, for which she is receiving valuable consideration. Now let's understand what were the crux of the arguments advanced by Anushka Sharma. Essentially, Anushka Sharma का ये कहना था कि she does not have the copyright in her work which is under question essentially, so there is no question of transfer of the same. So she argued or submitted that the taxmen have erroneously noted that she had acquired copyright through endorsements and by anchoring award functions and had sold or transferred it. Sales tax cannot be levied unless it's established that there is a sale of goods. The petition argued that she does not possess any copyright, and as such, the question of transferring or selling the copyright to any other person does not arrive at all because she does not have the copyright in the first place. So, the assessing of officer's contention that she has transferred or sold copyrights, it has no factual or legal basis, the petition argued or stated. The actor argued further that as per section 2D of the Copyright Act, the producer of the show is the original creator who always owns the copyright of the videos. An actor who has performed any role in the film cannot be called the creator or the producer of the film and hence does not own the copyright in it. Sharma further said that she is a performer under the law and she has acquired performers' rights under section 38 and 38A of the Copyright Act. We are going to have a discussion around this particular provision ki ye kya hai. However, the performer's rights vested in her, they are not copyrights and they are not capable of being transferred. Now let's understand the concept of performer's right. See, as far as section 38 of the Copyrights Act of 1957 is concerned, as amended in the year 2012, it recognizes performance rights where the performer engages in any performance including literary work, song or movie and the same subsists in the concerned person for 50 years from the beginning of the calendar year next following the year in which the performance is made. So essentially copyright of a song is licensed. अगर किसी song का copyright जो है it is licensed, and then not just the producer but the singer and lyricist too, they would be entitled to a share of royalty, and importantly the rights under this provision it cannot be waived or diluted through a contract. जिसका मतलब ये हुआ कि अगर कोई जो परफॉर्मर्स राइट्स हैं वो हम ट्रांसफ़र नहीं कर सकते, ना ही फर्दर वो सोल्ड करे जा सकते हैं बाय वर्च्यू ऑफ एन अग्रीमेंट. सो दिस वाज डन एसेंशियली टू प्रोटेक्ट द आर्टिस्ट, टू इंश्योर दैट हर वर्क रिमेन्ड विद हर एंड प्रोडक्शन हाउसेस कुड not simply buy her out. Now let's understand हाई कोर्ट का क्या डिसीजन था और हाई कोर्ट का क्या रवैया था इस पर्टिकुलर मैटर में. सो दी हाई कोर्ट डिड नॉट गो इनटू द मेरिट्स ऑफ द केस, जैसे कि हमने पहले भी डिस्कस किया था, क्योंकि ये जो पर्टिकुलर एक्ट है 2002 का, इसमें एक प्रोसेस है अपील की अगेंस्ट द असेसमेंट. सो द 2002 एक्ट प्रोवाइड्स फॉर अ प्रोसेस ऑफ अपील अगेंस्ट द असेसमेंट. द टैक्समैन ऑब्जेक्टेड टू Sharma's plea since she had an alternative efficacious remedy under the law. However, under the appeals process, she would have to be required to deposit 10% of the tax demand before the appeal could be taken up. Now, this requirement would have been bypassed agar High Court intervene kar dete. Now, with this, we've come to the end for today's TNA. If you want to get access to the free study material which is provided by LawSikho, or you want to get access to the TNA slides, please feel free to join our Telegram channel using the link in the description or scanning the barcode here. You may get in contact with LawSikho using these 2 points of contacts. Also, the daily quiz based on yesterday's TNA is made available in the description of this video for your kind reference. Please attempt the same. Thank you for being with us.